Okay. Thank you so much for your patience. I am Jane Bailey. I'm a law professor at the University of Ottawa Faculty of Law in the Common Law section. I'm also co-leader of Working Group 3 of the ACT project, along with Dr. Jacqueline Burkell of Western University. Working Group 3 of the project focuses on ethical considerations relating to uses of digital technologies to improve access to justice. And the ACT project itself is devoted to understanding how digital technologies can be used in ways that help to empower participants in the legal process and in legal systems. Today's session is the second in a 5-part series that's sponsored by the Working Group 3. And the overall series focuses on large language models and the legal system writ large. In our first session in the 5-part series, we heard from Dr. Mark Daly of Western University about the sort of general lay of the land in terms of large language models and their sort of relationship with of AI, their potential and existing uses, and as well as some of their challenges. And we'd also recommended to those who are participating today that they could take a look at video from Maria Lapata, which was a Turing Institute lecture that she gave relating to kind of breaking down even more and in more specific ways how LLMs actually work, large language models. So that has set the stage for this, our second session in the series, where we're turning our attention specifically to legal applications and implications by focusing on AI, large language models, and law schools, both in terms of research and teaching. And I'm really happy to welcome our 2 other panelists for today. Marina Pavlovic is a member of the Center for Law, Technology, and Society at the University of Ottawa. She's coordinator of the Law and Technology and Dispute Resolution and Professionalism options at Ottawa's Faculty of Law, also in the Common Law section. She holds a law degree from the Faculty of Law at the University of Belgrade in Serbia and an LLM with a concentration in Law and Technology from the University of Ottawa, and she is called to the Ontario Bar. Welcome, Marina. We also have with us today Wolfgang Alschner, who is a empirical legal scholar specialized in international economic law and the computational analysis of law. Wolfgang joins us today from Germany as well. He is on sabbatical, so thank you for taking the time. He holds the Hyman Soloway Chair in Business and Trade Law. His 2022 book, Investment Arbitration and State-Driven Reform, New Treaties, Old Outcomes, was recently was published by Oxford University Press. And it looks at how a new generation of international investment treaties has been rolled back in investment arbitration practice. He's also going to tell us about an exciting new project, in particular AI-related project that's forthcoming from the faculty in our discussion today. He's an associate professor at the Common Law section at Ottawa with a cross appointment to the Faculty of Engineering, the School of Electrical Engineering and Computer Science. And he too is a faculty member for the Center for Law, Technology, and Society at Ottawa, and he heads the Ottawa Legal Technology Lab. So thank you, Wolfgang, for joining us as well. So that our proposal here is to begin this with a moderated discussion, and then opening up for questions, which you will either be able to pose in the chat, or you can, sorry, the computer's just asked me to confirm the language I'm speaking in, which doesn't bode well for my understandability, perhaps. So you'll be able to pose questions in the chat, or if you would rather verbalize your question, you feel free to put up your hand, and Alexis will open it up so that you can, so that you're unmuted and you can ask your question verbally. So I'm going to kick things off with a question for Wolfgang. Ask if you could say a little bit more about how large language models work and how they're being used or could be used in the context of law schools, whether by professors or students.
Thank you very much, Jane, and thank you very much to the working group for inviting me today to speak to you. So you have already received an introduction into how LLMs work, so I'll keep this brief. Large language models are the latest achievement in artificial intelligence research, the latest models in what we know as machine learning. The way they work is that they've been trained on millions of documents. We can talk about the video and the audio component perhaps later in the Q&A, but let's focus on the text component. And they've been trained in order to predict the next word in a sequence. And so these are probabilistic predictive algorithms that have encountered large amounts of text and can therefore generate their own text. And there are really two main takeaways that I think are important for all of us to keep in mind from this very basic description of how they work. The first thing is that large language models are language models. They are not knowledge models, but because they have seen millions of documents. Imagine if you had read the entire internet, you would be knowledgeable about a lot of different domains. And so there is latent knowledge encoded in that language model by virtue of it having been trained on all those documents. And that's, of course, very important because it can do then things that are actually quite surprising from a language model. If you ask it to give you travel advice, it will often provide very pertinent travel advice. If you ask it what's the difference between nuclear fusion, nuclear fission, it will give a very cogent answer. And what is important for us today is that these large language models have been trained also on large legal corpora, so statutes, case law, and therefore there is a degree of legal language that's legal knowledge that's encoded in these models as well. So they are not databases, and it's very important to acknowledge that distinction, but there is knowledge encoded in those language models, and we can tap into that knowledge in some of the use cases. That's the first thing we have to keep in mind. The second thing is that they are predictive algorithms. And that's very different from, for instance, a database where you would do a search query such as Canly or a Westlaw search, where in information science, it is about an information retrieval task. So you're interested in a particular information and the system takes out that information. Large language models work differently. They predict the next word based on, for instance, in a chatbot, the prompt that you have given it. And so it's about likelihood. It's about what is the most probable next word. And that means that there's sometimes incorrect information. The large language model is making up things. That's called hallucination. But it also means that the expectation shouldn't be that this is something that is useful for research necessarily or for information retrieval, because that's really not what's going on. Prediction is what is happening. And when we keep these two things in mind, it is relatively clear then what types of applications, use cases we can imagine for those types of tools in a law school setting. And I'll just briefly in these introductory remarks tell you about two things that I've used it for in my own teaching, and then I can talk a little bit later about some of the research applications. So last year I taught a course in international trade law, and I used LLMs for two distinct exercises. The first was a negotiation exercise. There are lots of negotiations currently happening in international trade law, and so I divided my class into groups representing different countries, and they had a particular issue, in that case, a dispute settlement reform to negotiate. And so what did the students do? They had information about the country positions, and they were then negotiating prompts for ChatGPT. So they were not negotiating legal texts, they were negotiating the instructions that would be given to that large language model. And because the large language model, as I said, has been trained on a lot of legal texts, it actually spits out relatively useful drafted text. So we can think about it similarly to negotiators coming together to give tasks to legal drafting experts to then distill those policy ideas into legal language. And the second part of that exercise then was about the students engaging with the language that has been produced by the LLM in order to say, where did it follow these instructions? Where can we improve on it? So it's really about how we integrate large language models into our workflow. The second task that I used it for, the second exercise, was something that I find even more fascinating, and that is synthesis of information and looking at the same issue from different perspectives. Because the LLMs have seen so much information, we can actually use it in order to wear different hats. And so one of the big debates in international trade law is, where should we go next? States are very dissatisfied with how the system works. Since the pandemic, we talk about more resilience, more equality, more opportunities for developing countries. And these are all different lenses that we can bring to bear to talk about and to think about legal problems. And so what I asked the students is I gave them essentially a prompt with a blank, and the blank was the specific lens, the theoretical lens that they wanted to know more about. And then they could look at a specific legal problem through that legal lens. What do I mean? I mean, for instance, TWAIL, so a third world approaches to international law. So how would a third world legal scholar look at that legal problem? How would an economist look at that legal problem? How would somebody who is concerned about human rights look at that very same problem? And because the large language models can tap into information associated with these different theoretical perspectives, they bring to bear perspectives that we might not otherwise have ourselves. And that then contributes to more holistic analysis of problems. So these are just two use cases I've encountered in my teaching. I'll be talking more about the research side later on, but I think this is enough to kick us off.
Yeah, that's really helpful. Those are like really helpful, like grounded examples to get sort of people thinking about what might this actually look like. Marina, I'm wondering how are you thinking about, as we hear more and more discussion of people in practice engaging with large language models and AI in a variety of sort of different ways, and what do you think is teaching law students how to engage with large language models going to become a necessary skill, along with the other skills that case analysis or something that we develop in law school?
So I'd say short answer is yes. And I would actually posit that learning how to work with LLMs and generative AI, and perhaps even more importantly, critically assessing how to use them, is an important skill that's going to be very important in higher education generally. So post-secondary education writ large. I think law schools and other professional schools, like medical schools, though, create unique environments and pose unique challenges. And so I think in law schools in particular, there's this constant tension between theory and practice. Do we need to graduate practice-ready lawyers or students who are practice-ready, or is the role of a law school to focus on critical thinking? And I personally see it as a shared ecosystem where each part plays a role. They are distinct and there is some overlap. It's sort of like a Venn diagram, but each actually has its own distinct role. And I think against that background, I think it's important for law schools to incorporate some skill development. I don't think we need to go granular and teach students how to perhaps design prompts or do prompt engineering. I would compare that more to some students know how to use headings in words, some don't. Some know how to use cross references in Word, but like when they get to practice, each firm sort of has its own way of doing things, and they're practical things that you can actually learn in practice, perhaps a little bit better and faster. But I think the core of what we should look into law schools is actually that critical assessment. And Wolfgang has identified, where LLMs are very good, and he's also identified where they're not that good. And I think knowing when they're not good and when they can pose challenges is really important to understand the breadth of the work that they can do. And so sometimes they're really good because they save time, but sometimes they're really not because you have to kind of redo the whole work. So I think there is value in exposing students to it. I think we're still fairly early in the process in terms of how is that going to look like. And at least in our law school, as you know, we've relied on individual instructors. So there are people like Wolfgang or me who have actually done a lot of work, and there are more people who are a little bit more skeptical or perhaps feel that they don't have the capacity to do it. So I think a lot of it is also going to hinge on building capacity of instructors to both understand the technology and the capability of technology so that they can then decide what would be the appropriate way to use it in classrooms.
Yeah, that's a like really sort of important observations, and I think like there are a number of things that affect instructors' willingness to engage. Some of them are, it's like with any other kind of technology, a sense of a lack of knowledge or familiarity. But I also think that for a number of us, I would say myself included, there are some sort of foundational concerns about LLMs that many of which actually spill over into all kinds of the technologies that we use in schools, including things like Brightspace and Zoom, Microsoft Teams, like there are, our email systems. There, I suppose, in my mind, there's something about large language models and sort of generative AI that have really started me thinking more specifically about those things as we in another project, we're looking at the use of artificial intelligence in education and raising the concern that many teachers raise in elementary and high school systems about the pressure to use technology, to expose students to technology, while at the same time receiving actually very little information about some of the underlying issues. Examples, obviously, bias, the production and reproduction of bias based on the training data. So bias in results, copyright issues. We in the session with Professor Daly, we talked about that last time about people are asking, people whose content is being used as raw material as sources for AI generated outcomes. There's ongoing litigation around copyright issues, around moral rights issues, about who should have the say on what can be included in this training, in these training sets. And really interesting questions around artists who are talking about seeing the essence of their representations being reproduced in the results of generative AI systems. Other things, obviously, privacy concerns, very basic ones that relate to data security and those sorts of things, but also what's being done with the search terms that we enter in. Are they tracked? Are they monitored? Or do they become somehow a part of profiling? What are the related privacy policies of the different technologies? And to the extent that we're asking students to engage with them, what is our responsibility to know that? And again, this is not confined to generative AI. It's just I feel like these are questions that have been coming to a head for a while, and now with the explosion of the sort of chat GPTs of the world, it's really led people to start thinking about these questions. And certainly I think probably one of the most predominant ones that people are talking about in educational and law school environments are concerns around plagiarism. Whether people submitting GPT produced papers or exam responses, and larger concerns maybe like those that our dear colleague Ian Kerr raised about all sorts of technologies, which was, what are there important skills and values that humans will be deprived, virtues, that humans will be deprived of the ability to practice if we relegate certain tasks to generative AI. And the one I think about a lot, it goes back to Wolfgang's point about hallucinations, is, you know, if that, does it mean a change in the other kinds of skills we build in students? Like, do students no longer need to be able to read a case because they're you know, the technology will eventually, you know, it seems to improve every generation. It'll eventually be so much faster and so much more, quote unquote, you know, scare quotes, accurate, that, you know, lawyers and students will be able to move on to what many might see as less mundane tasks. But in the interim, you know, if we lose the skill, who checks the AI, right? How do we develop the skills we need to see if the AI is accurate? So there's just like this whole morass of things that are always circulating in my mind and have been for a while. Wolfgang, I wondered, as someone who's used LLMs in your research and also as you've described in your teaching, do you have advice for other legal researchers who do want to engage with generative AI, with large language models, but are concerned about these issues?
Well, I might speak more about the opportunities and leave it maybe to you, Jane, and Marina to talk about some of the concerns, or come back to it in the end, in order to have a bit of a balanced view of opportunities and risks. So I am, in terms of some of the opportunities, there are really three types of buckets of research that I'm doing, and LLMs play a role in each of them. So I do computer science research, where really it is impossible these days to do computer science research without LLMs, just because they are better at virtually every task that researchers are trying to solve. And so it has become an imperative to work with LLMs, just because they are now the research frontier. So that's, I think, something very important to keep in mind, that there are lots of people, virtually all of computer science, are working on this, which contributes to these tools becoming even more powerful in the future. The second part that I use LLMs for relates to some of my empirical research. And as Jane sort of previewed a little bit, we have a forthcoming book on the Canadian Supreme Court, where we use the range of data analysis techniques in order to look at the Supreme Court of Canada over time, see some of the changes in the types of language it adopted, changing precedents, important precedents, identifying those. And technology can be used in order to track those large corpora of jurisprudence like those of the Supreme Court of Canada very effectively, because scale is not an issue for these tools, right? It would take us a long time to read all these decisions. LLMs can do those in seconds or minutes. And so that's a second opportunity that I think will be very important in the future. Empirical research is becoming much cheaper than it used to be. The third aspect relates more to traditional legal research, where I think LLMs have a role to play. I think about LLMs a little bit like a very intelligent and knowledgeable and diligent colleague that you might go to ask for advice. You wouldn't go to your colleague and say, write this research paper for me, but you might go to your colleague saying, look, could you read this paper over? Can I improve my language here? Do you have some editing suggestions? What do you think about this argument? Can you come up with counter arguments, or can you tell me your views on how to make this more nuanced? Those are the types of things on which LLMs can provide effective feedback. And so I think thinking about LLMs for in terms of knowledgeable colleagues is something to really keep in mind for all of us. We don't always listen to what our colleagues tell us, so we don't farm out our critical thinking, but it is always nice to have another pair of eyes, even if they are virtual rather than human.
Yeah, again, really helpful examples and really nice, like, it's like a lot of other technologies, it's like the self-driving cars. There will always be people who, like get in their self-driving car and, lay down in the back, turn it on and lay down in the back seat. And then questions get raised about where's the problem here? Is the problem with the user? Is it the problem with the technology? And it's almost always some kind of an intersection and interaction between those things, where humans have to make good judgments about what the appropriate or the right or the use of the technology is. And then we also have to think about what are there design features in the technology that sort of help to support humans to make those
Olá,
good
tudo
choices.
bom?
Oh, I think I think that was just a mistake with someone's microphone. Marina, this is open to you, Marina and Wolfgang. The three of us, which is what in part brought us here, were members of an ad hoc committee that developed in the late summer or early fall some guidelines to help our peers at U Ottawa Law faculty think about how to interact with generative AI in the classroom, especially its use by students. And so I just wondered, stemming from that exercise, I think, Wolfgang, you've already maybe in a way highlighted some of these, but what do you think might be some of the best practices that law schools and law professors could be thinking about? Maybe, Marina, maybe I'll bat it over to you first.
So I think I might start with something a little bit controversial. I think a wholesale ban on LLMs and generative AI is not the way to go, because it creates this forbidden fruit where then everybody wants to use it but not disclose it, and then it's used indiscriminately for for things for which it's good, but also for things that it's not. So I do think there is a net benefit, and I think part of it is that it forces us as instructors to reevaluate what we teach, how we teach, and what are the learning objectives that we want students to take away, and then how can we achieve those learning objectives. And we all know as teachers that there are multiple ways that you can achieve a certain learning objectives, that there isn't a singular way to do it, because 7 people teaching the same course are going to teach it very differently and achieve those learning objectives. So in that policy that we created for our faculty that we worked on, we did put a ban on the use of AI in exams, because we firmly believe that there is a particular learning objective of the exams to demonstrate both the subject matter knowledge, but also analytical skills, and that we can't really evaluate that if the students use LLMs. But there are other ways that we can help them, again, build those skills. And I think in particular, in light of all of the challenges and questions that you identified, Jane, to help them actually develop and build resilience in terms of, again, when it's appropriate and when it's not. And as Wolfgang, I used it in my, I had a very generous AI policy in a couple of my upper year courses, and I'll just give you a couple of examples where the students found where it worked really well and where it didn't really work well. So in one of my classes, I had students participate in a mock hearing before an administrative tribunal, the Canadian Radio, Television and Telecommunications Commission, representing assigned parties. And so I actually told them to ask ChatGPT or GPT-4 to help them create the argument. And it really sucked at that, right? Because it's very good at saying, like, one side says this, the other one side says that, but it's actually not really good in advocating without a lot of prompts. And then we said, okay, so now you go back, you design the argument, what you're going to actually argue, and then we're going to go back to ChatGPT and see what it can help you with. And where it was absolutely phenomenal was when students actually created their argument and had a draft to help them write it in the language of their client. So if they represented Bell Canada or Netflix or Canadian Civil Liberties Association, ChatGPT was really good in sort of harnessing, the works of those clients in other administrative settings and creating the document that actually sounded as if Bell wrote it. And where it was also very, very good was in creating questions to help students prepare for the oral argument and kind of poke holes in their arguments to help them then in the next draft integrate some of that stuff. So as Wolfgang said, like, it's not really good in, if you ask it to do something for you, it's not going to write a very good paper. but with number of different prompts, it can actually help you edit it and make it tighter. And I think that's, for me, that's the biggest value for students, to understand that there is still incredibly important place for those core skills where, and, you know, part of the job of a lawyer is advancing novel legal arguments. And work that Wolfgang has done in the past, even before the emergence of LLMs, you know, it's very good because you can analyze large volumes of data and predict, you know, which judges can go this way or that way. But sometimes our job is actually to push the envelope and create something new. And, you know, ChatGPT can help us in that, but it can't really do it, because sometimes you really need to create something that hasn't existed before, you know, because your client rights have been violated in a way that hasn't really existed before, and you need to really create a unique argument. So I think there is value in using it, but I think we all have to come into it with open eyes. And again, us as instructors understanding both the limitations and some of the challenges that you identified, so that the students themselves understand that, because I'm not really sure that some of them actually understand some of the sort of underlying issues that you identified, including, you know, copyright and privacy, and you know, larger issue of data surveillance with all of this information, and you know, this digital track that we're all leaving behind.
Wolfgang, do you have things that you would like to sort of add to that?
I would just reinforce some of the points that Marina made, that I think it's really crucial to foster engagement with that technology, because if you just ban it, then by definition there's no engagement there. And I think what we shouldn't forget is that this is something that is relatively new. This is a learning experience for us as instructors. It's a learning experience for students. It's actually a learning experience for us as a civilization as well, because we are only now exploring some of the use cases to which these tools can be put. And so we shouldn't deprive our next generation of lawyers from that type of experience, but rather make them part of that journey. And I think fostering a spirit in a law school where experimentation is possible while highlighting some of the downsides and some of the dangers is probably the better way to go than to go for either a blind adoption or a very strict ban.
Yeah, it's interesting. So the approach that I took was kind of a hybrid, where I start from the proposition that I'll assume that that generative AI will not be used, obviously ever in exams, but in sort of essays and other kind of written work, that it won't be used. And then the student provides an attestation to that effect. Or if the student wants to use generative AI, then I invite them to come and have a conversation with me about why, and what is it that they're planning to do with it, and then we can talk about, you know, does that seem like a good use of that? What are the implications of that? And so forth. And so far I've had a couple of students who have come forward and used, in both cases actually, generative AI to produce images based on prompts that are in part designed to demonstrate bias, right? So what happens if you type in the word, you know, woman lawyer, versus if you type in the word male lawyer, or and to see the kind of or female avatar versus male avatar, and to see to see whether stereotypes and so on get how they get reproduced or they don't. So again, I have let the students lead with the creativity, and I've been kind of happy with the result, in the sense that it's produced a dialogue, which I think is kind of what we need. And I feel like a definite predisposition one way or another doesn't necessarily do that, because it doesn't engage the professor and the student in a conversation. It's just an independent decision that's made the student and then evaluated by the professor. So that's been that has been an interesting experiment for me. Nobody's come forward and said, I'd like to insert the question you've asked me to write an essay on as the prompt, and which we obviously have to have a difficult conversation about. Well, not that difficult for me, but perhaps for them. But so yeah, I mean, I'm not surprised by student ingenuity. Students are, I learn from students every day. That's the advantage of being a professor. You get to learn every day. Have either of you received any feedback from our colleagues about the kind of guidelines that we provided to them, or have you had conversations with colleagues about other things that they feel like they could use support on to sort of move forward in this on this journey that we're on?
So perhaps I'll start, and then Wolfgang can add if I miss something. I think there was originally a huge sense of relief amongst the colleagues that we came up with the policy so that there would be at least some guidance. And what we've done, so for those of you who don't know, we created a policy where AI is not permitted on the exams. For everything else, there were different types of uses that could be permitted, and for each, the student would have to disclose. So if for example, they not only they would have to disclose that they've used it, they basically had to actually disclose what kind of prompts they've used. And then for exams that were not in person, so that were administered remotely, the students would have to sign an attestation that they haven't used ChatGPT. So I actually plugged all of my exam questions for my private international law into ChatGPT to see what kind of answers it would give, and it was completely useless. So I felt comfortable with my exam questions, and I think that's going to be another sort of layer for me for some of the exams to in terms of what I'm looking for them to demonstrate, is it something that ChatGPT can do for them? We're currently collecting data for our winter term. In the fall term, it was really a mixed bag. Some colleagues completely banned it. Some colleagues allowed it, it along the lines that Wolfgang and I did. Some did what sort of Jane, you did as well. And I think one thing that may drive some of this may be the class size. It's much easier to engage with students in graduate or undergraduate seminar courses versus when you have a large group or 80 or 90 students, where it is very difficult, given the class size and sort of the pedagogy, to kind of engage on these issues. One thing, so I've had a number of conversations with, colleagues would say, okay, I'm concerned about, hallucinations. What do I do? And then we would sit and sort of brainstorm. And one of the things, I'm not really concerned about hallucinations, because I think we already have in practice ways to deal with that, right? So when you write a factum or a motion to the court, you have to submit your book of authorities. So if ChatGPT created cases for you, they would have to be in the book of authority. So if you don't do that, to me, that's just professional negligence, right? There are different ways that we can check for some of those hallucinations. But one thing that was identified, which we didn't really, which we decided not to deal with when we created the policy, is that generative AI is now integrated in a number of different tools that people use on a daily basis, including Grammarly or DeepL, which is a translation software. And there are some concerns both by students and colleagues in terms of how to disclose that, because the embedded AI in these tools is not creating context and content. It's just helping with editing, but where does that kind of fit on the spectrum? And I think that's one of the things that we would have to address. And I know that's also the thing that the Ontario Law School Council, or whatever the name is, that administers all the applications to law schools in Ontario, has been struggling with for students' personal statements in terms of, what is the permissible use of AI. So I think there is room for refinement of the policy based on what we've learned and what colleagues have experienced, and also looking into some of these new uses, which are not generative AI proper, but it's sort of, I would say, generative AI related or embedded in under other technologies. And, Microsoft Word already has it embedded. So how do you disclose that you use it if you don't know that you've used it, and that kind of stuff? Wolfgang, over to you.
Yeah, I would just elaborate a little bit on that last point, that it's, I think just thinking about the issue through the interface of just ChatGPT is really just a small part of the bigger picture. And as we're moving towards a workplace environment where machines and humans work ever more seamlessly together, it is really not practical to disclose the use of artificial intelligence or technology, for that matter, in the future, because it's so infused in everything that we do. And so we have to think about different ways in which we manage then what is the human part, what's the machine part, and does it even to some extent matter. So I think we are now at the beginning of a journey that is going to get only more complicated and not less complicated, I'm afraid.
Yeah, absolutely. And we have, there are predecessors like in history, right? Like I think about the calculator, and like will people be like people won't know how to add anymore, and those kind of arguments that were made. And I mean this is just on a I mean it's on a larger scale, I suppose, or maybe not even on a larger scale. It's just a different thing because it's not numbers, it's words. There was one other thing we were going to talk about, but I think I'd like to open it up. I think if I'm recognizing some of the names here, I think we actually have some students at sort of different levels of their law school journey in the group. Do people have questions or sort of comments about experiences or perspectives that they have on the use of generative AI in along your academic journey? I see there's something in the chat. Oh, this was just a thank you to the speakers. That was lovely. Anybody have anything they want to contribute, like things you'd like to know, maybe things you have you had experiences with these policies in the institutions where you're going? Do you feel professors are out of date? Do you we'd be happy to sort of hear your experiences, or if you have particular questions. Maybe in the meantime, while maybe people think a little bit, we can talk a little bit about resources. Are there resources that either of you have found that you thought were particularly helpful in thinking through these issues? And in a lot of ways, the scholarship is we're kind of at the beginning of the arc of scholarship, I think. But any resources that you recommend or that you've sort of found helpful in thinking about how to use these technologies or the limits of them and so forth?
Okay, so I'll start quickly because I think Wolfgang probably has a much better bank of useful information. So I've attended, I think, pretty much every lecture that there was on the use of AI in education. And I frankly found it overwhelming because there is so much, and I hasten to say some of it is noise. I think part of it is also that, like all of a sudden there is so much information what people are doing, and you kind of lose track of what you want to do. So I really think individual instructors in particular need to sort of figure out what they want to achieve, like what are the learning objectives, and then sort of reverse engineer from there versus like, oh, here are all these things that the technology can do, and how can I sort of achieve all of these things. So there are incredible things that people are doing. So along the lines of what Eugene mentioned, it's not even, to expose biases, it's not even, how would a female lawyer look like? Like, give me a picture of a lawyer and then there comes a man, right? Or give me a picture of a doctor and there comes a man, right? So I think some of those are not necessarily useful in law school. For us, I think it's really more in terms of, okay, so can you sort of figure out if there are particular groups that are unfairly treated by the judges in like sentencing decisions, et cetera. So I actually found what was very useful for my students, and I'll paste it in the chat. Dartmouth College had a very good sort of like, here are useful prompts if you want ChatGPT to do a bunch of different things. It's fairly basic, but I think for a lot of people who haven't used it, it takes a while to sort of figure out how to actually do it and how to write prompts that are useful. And sometimes I think by the time you get to a good prompt, you could have probably done the job yourself, right? And so I think obviously as you write more prompts, you get better. But I think understanding how to ask it to do something that's actually useful for you is very important. I would assume Wolfgang has, again, a much broader tool of sort of tools. So I'll paste the one that I thought that was useful sort of to get you started and that the students actually found valuable. And then you can obviously adjust it to the, either area of law or area of study if you're not a lawyer.
Yeah, well, that's really helpful actually, and Wolfgang, because there is a, and I'm thinking you may have some thoughts on this. So one of the question in the chat was, how do you get better at writing prompts? Like, what are the things that distinguish an effective prompt from maybe a less effective one? In this context, it's for engineering specifically, if you want to compare data from the judgment and maybe see the evolution of the language, what are some of the things you think about or you help your students think about when they're crafting prompts and in your uses in the classroom?
Yeah, I think it's an excellent question, and Marina posted this really helpful cheat sheet in the chat, and I think that's a really good starting point. I think in general, it's really important to get your hands dirty and to just play around with different prompts and to just get a sense of what works, what doesn't. Of course, then you can tap into some of the advice. If you do a step-by-step analysis, it's often a little bit more reasons. There are other little pieces of advice that you can produce better prompts. It's also always important to layer the conversation. So you might start with one prompt, and then depending on how satisfied you are with the answer, you then drill down or you ask it to approach it slightly differently. So to not think about it as a one-off engagement, but really more of a conversation. I think the particular question with respect to tracking judgment styles and writing styles over time, you have to have a very solid theoretical foundation, what you're looking for. So again, the farming out of research questions is not what you can do through ChatGPT. It's maybe part of the implementation, but even there you have to be very hands-on. I think the last piece of advice that I would give everyone is to really stay informed about developments in the field. So I love listening to podcasts, and A Hard Fork by the New York Times is an excellent podcast on the advancement of technology, and it's really moving so rapidly that I think it's very important for us to stay tuned.
Sorry, I think someone's microphone must have gone on by accident.
I was done.
Okay, thank you for that. That Dr. Daly in the first session gave a few comments, like generalized comments. Oh, we need Wolfgang. Would you be able to put the name of the podcast into the chat for student? Thank you for the participants. One of the things that stuck with me. Yes, it's an iterative process, as you've said, Wolfgang, but also the idea that it's helpful to tell it what your audience is. Like, who are you writing this for? Will often be a really helpful framing, even though you may have to still do things iteratively. Giving a direction as to who are you trying to convince, or who are you trying to convey the information to, is a really important one. And also an important, obviously it's an important, that's an important skill for legal practitioners to be thinking about, law students and legal practitioners. Who are you talking to? A judge, a policymaker, a client? Like how you make your pitch and is significantly affected by who your audience is. So that was one of the tips that he suggested that I thought was really helpful, and I wouldn't necessarily have thought about. Any other comments or questions? We're close to coming to a close. One of the things I wondered, and I could probably read more about this, is one of the things that when the pandemic came and we all gravitated to Zoom, one of the things that many of us who are interested in privacy really encouraged was for there to be specific institutional licenses negotiated with these platforms to make sure that privacy rules and norms unique to our jurisdiction or our institution are respected. And I don't know if any of that is coming in the generative AI field or not, because that in part to me seems to be one of those places where if people like me who are reticent to encourage use because we simply don't know about those parameters, it feels like one of the things institutions could do for us that would make it more comfortable to students are using the content anyway, but I take that as a different thing to me telling them to engage with these platforms, and so or products, and I don't know if either of you know of whether that's institutional licensing sort of things are in the future or not.
So as somebody who taught contracts with you, I'm going to say it's usually not on people's minds, right? Like those are such remote, intangible risks that those negotiating these contracts often don't pay attention to, which doesn't mean that they're not important, right? And so I think we need to, as contract scholars in particular, need to push the needle much further to sort of say, like these are really in the end standard form contracts that institutions sign on behalf of hundreds or thousands of people. But I just wanted to go back just slightly to some of the questions that you raised, and I think one thing that I'm hoping that these tools can help us actually do better is be better lawyers who communicate in plain language to clients and other audiences so that they would actually understand what we do, right? And so I think there is a huge value in using these tools to help you draft client advice letters that actually are understandable to the clients, right? Where the client actually understands what you're saying and what the implications are. And I would hope that we're going to use them in the future to redraft some of these horrific contracts where nobody really knows what they're saying, right? So that aside from, it would also be good to have clauses that are beneficial to both sides of the contractual bargain, but at least to help us work with some of the clunky language that has been developed over generations and generations. So I am optimistic, at least, that some of the plain language movement may actually be materialized. And I know there is one lecture coming up about that. So I'm looking forward to attending that one.
Yeah, thank you, Marina. Yeah, there's one last question in the chat. I don't know if we'll be able to provide an answer to it, but one of the questions, it's a question about, how do you begin the process of fact checking if you actually don't know the source of the information that's being provided to you, right? Like you don't know where the response was drawn from. Where does the fact checking begin? Any suggestions on that?
Well, I think it's important to keep in mind that this is latent knowledge, as I said, that has been encoded in the language model. So potentially there are lots of errors and they are not easily identifiable. So I would always use it as an entry point, whatever text is being provided, but never copy it or sort of take it at face value, but as a starting point for then doing actual research using databases whose purpose it is to provide verifiable information.
Yeah, I think that's really helpful. And then for a lot of people, it gives them the feeling that it kind of defeats the purpose. But I think that's what the really important point is that you're making, which is it's a support tool. It's not a substitute for doing the research. And there was one last question in the chat, to which thank you, Marina, responded in the chat, about whether policies on generative AI should just get incorporated into existing plagiarism policies, or whether they should be sort of standalone things. And Marina's given the example at U Ottawa, it was integrated into our academic integrity policy. Now, I see it's 1:30, so I'm afraid we have to close things off. Thank you so much for your participation and your interest. Thanks to Wolfgang and Marina for sharing your experience and your insights. I'm sure this is just the beginning of many conversations to come that I hope all of us are going to be having. And the fact that it can be difficult to have it with students in larger classroom settings is a great other reason why we should be lobbying for smaller class settings, so that we can have the important conversations we need to be having.